Since then, we've had several phone calls and text messages that were sent by my office that have been completely ignored. She's not here, so I request an order to show cause. The subpoena was served on her by State Attorney Investigator Hamrick on August 27th of 2025. I have it here for the court's review.
Do you have a prepared order?
Not yet, no.
Okay.
I can get the court that, yeah.
Yeah, Mr. Cormier has done them before, so he's familiar with the form, right? Yeah.
Okay.
All right, so I would grant that, yeah.
Okay. Next, the trial exhibit 183 that was discussed yesterday, that was decided, the state's no longer going to be moving that into evidence or attempting to use that as evidence based on the defense position. So my request is to simply have that marked as a court exhibit in order for it to be preserved for any future legal proceedings.
I'll grant that request to avoid any accidental giving it to the jury during deliberations, which would be very, very problematic.
Yeah.
Yeah.
So it's trial exhibit 183 and
Right. And actually, if you want to take it back to the clerk's office on break, just so it's not here for that purpose, to avoid any problem.
and that will be marked as court exhibit 1.
Yeah.
Okay. And then the final issue I wanted to raise, because I thought this might save some time before the jury comes in, is the procedure that we're going to use to elicit the testimony of FBI translator Norma Campos. She will testify this morning, and what we intend to do is to use Lieutenant Andy Belanca as, in effect, as a demonstrative aid. He will read the transcribed translation in conjunction with Ms. Campos, and to read that to the jury.
Any objection to that procedure?
Would you lay that out again for us, Mr. Richards?
Is it because there are two speakers on the?
Yes,
Correct.
So she would testify, everything that you're about to hear is my expert opinion on what's being said, and it's going to be published to the jury in that form with two speakers, one being one and one being the other?
Yes.
As opposed to her saying, at this point, this person said this, and at this point, that person said that. That's
Yeah.
what your plan is.
Yes, sir. And as an additional matter, we prepared, I think, about 18 redacted transcripts. We're going to ask those transcripts to be used by the jury, not admitted into evidence, but to be followed along by
To
the jury.
follow along demonstratively.
Yeah.
What's the defense position?
Several things, Judge. One, I'm just going to contemporaneously, for the record, reiterate our objection under Martinez to the way that the state is introducing this evidence, and also make clear that I'm also raising an objection regarding authentication, both of the individuals speaking and who's speaking at which time, and that those are their voices. So I don't believe that the state has laid the appropriate predicate to authenticate who is in the truck and which voice is being heard. And then the third authentication issue is that the recording is actually an appropriate and true and correct copy of the conversation at the time. And I think that's discussed in Martinez, where the courts have found that the individual who's participating in the conversation at the time, i.e. in this case would be Eric Alvarado, has to come in to authenticate that the recording is a true and accurate copy of the conversation that it was had at the time. Or alternatively, an individual like in Martinez, who is law enforcement, who's contemporaneously listening to the audio recording as the recording is being made, that they can properly authenticate it. But we don't have that person in this case because no one was listening to the recording as it was being made. So again, it's our position that Eric Alvarado is necessary to lay the predicate for an appropriate authentication of the audio and video. One, that those are the individuals that are in the car, that each voice is correct, and that the recording itself, not the translation, but the recording of the words itself is actually correct. So that's the.
So could you restate that very last point? I'm not sure I followed that last one.
Yes, sir. That the recording of the words themselves are actually correct. So for example, that if an individual says, the person is behind the Wendy's, that's actually what was said.
Was it the part before that source? What is your argument on that point? Like, who is necessary to do that? That's what I lost you.
Oh, yes, sir. Our argument under Martinez is that it could either be one of the speakers that is participating in the conversation. The only two speakers in this case are allegedly my client and allegedly, again, Eric Alvarado, so that the state would need to present Eric Alvarado to properly authenticate both the video and audio recording that they are the two people in the video, that they are the two speakers in the video, that each voice is correctly attributed to each speaker, and that the words are the correct words that were said at the time. Martinez says that's the most preferred method as an individual participating in the conversation. You can also do it where a person who is listening to the conversation as the recording is being made contemporaneously, that they can come in and authenticate it. Because in Martinez, there's law enforcement who's listening to the recording at the time. We do not have that individual in this case because no one is listening to the recording as it's being made.
Okay, so we have two, if I'm correct, we have two issues buried within the objection. The first one is as to authentication, and as to the, in relation to that, whether I would allow the translator to, or the conduit person, Belanca, to say, I'm going to be playing this person, versus this is what's being said by the two people without identifying them. That's issue number one. And issue number two is whether someone hearing it live is necessary for this to be well, it's already in evidence, though. I said the second one. So I'm not sure that that's timely at this point because it is in evidence already.
We did make the same objection yesterday under Martinez that it was not properly authenticated prior to it coming in. I'm just reiterating it contemporaneously before we do more with it. But we did make that same objection yesterday under Martinez.
What's the state's position as to the 2 points?
Well, first, the court is right. Both exhibits were admitted without objection during the trial. The whole reason that I forgot that I did not call 6 witnesses was because it was to avoid the authentication problem, which they agreed to yesterday, but now are objecting to today. What I would say is it is in evidence. It can be played.
Let me ask you this,
Sure.
because this might be important to me.
Sure.
I have not reviewed the contents of the statements. Are there any statements by the two people that on their face would indicate which one is which?
Yes. Yes.
Like, for example, what?
Well, I mean, there are statements where Soto-Escalera is talking and he refers to the passenger by name. He says Eric.
Okay, all right. Because otherwise it was a valid objection. There's no one's come in and say, I know the voice of Mr. Soto-Escalera, that's him. But within the item, if it's by its contents, if it authenticates that issue, that would suffice and overcome the problem, which otherwise would have sustained. They would just have to say one person saying this, one person saying that. But I would require the expert witness to say, I identified one voice as Mr. Soto-Escalera because of that. So that's understood. And so I'll overrule that objection. What about the second part? Is it the same state position as to the second part?
What is the second part again?
Whether Eric Alvarado is necessary to identify and authenticate the contents of it.
He's not required because authentication can be done throughout by the context of the conversation. There's a case called State versus Love that routinely relied on, in which we do that. I would also say, given the evidence that we have here, the court has heard from Adolfo Cavelli, who clearly laid out the camera system and the audio system of the truck, the fact that the microphone is located close to the driver, which, as Ms. Campos will explain, Soto-Escalera's voice is is heard much more clearly because he was the driver, and Mr. Cavelli knows both of them, and he will come in at a later point during the trial. If you recall, I said that he was subject to recall. He's going to come in at a later point in the trial. We're going to play him both the audio and the video, and he's going to be able to personally identify both Cavelli as well as both Alvarado as well as Soto-Escalera. In addition to that, Detective Chris Newman can also do that because he has personally interviewed both participants, and he will also identify both participants in both of the states.
All right. As to that's the second point, whether Eric Alvarado is necessary. To my mind, the best way of analyzing that logically is, let's put aside the reality of who Mr. Alvarado is and where he is and what's going on with him now, which is kind of a red herring. But if we imagine a scenario where he was hit by a bus and he's no longer with us, he's dead, I can't imagine that would preclude the admission of this evidence in this case, so long as it can be authenticated, circumstantially or otherwise, that this is the defendant's garbage truck. He's talking with Mr. Alvarado, and it's relevant to the case. So that's compelling to me, that reality. So I'll overrule that objection. And I'll allow you to do it. I do want to make sure that it's clear that, and I think the state's going to do that, that this is coming in through a certified expert interpreter, and that you just don't jump into the whole, here's what's being said. So I'm quite sure you're going to lay the foundation for that.
Yeah.
Foundation's going to be made as far as this is expert testimony, as far as what's being said.
Mm-hmm. And one last issue when we finish this up.
Yeah.
I did speak. Go ahead.
Go ahead.
We weren't done on that. Again, under Martinez, we object still, just again contemporaneously, that this transcript is in this recording is going to become a focus of the trial. So we object to it coming in under Martinez.
On that point, maybe the dangling chad there that it indirectly addresses the use of the transcript demonstratively separate, because everything I said was really separate from using the transcript demonstratively. In the case law with regard to that, does it address this issue particularly? That is, in this case, the procedure we're utilizing, that I'm giving my blessing to, is expert comes in for the state and they're qualified and they're going to testify. This is what's being said. Purely the issue of using the transcript the state intends to is seeking to hand the transcript, each copy, for a juror to follow along with?
Yes, sir. A redacted copy.
On that particular point, did the case law that you're relying on either side address that particular procedural aspect of this? Or is it simply admitting the transcript, as evidence?
As far as relying on it as a demonstrative agent?
Right.
I believe Martinez discusses relying on a transcript, and then it talks about it should not become the focus of the trial. And again, that's my argument, on top of all the other arguments we've already made, flowing from Martinez, that this transcript will become a focus of the trial. And my secondary objection to that is it still invades the province of the jury. It's up to the jury to determine, number one, what is being said, which is further complicated in this case because it's not in English, but two, who the speakers are. So I understand the court's ruling. However, if
Let me just clarify my question, because I think it's come clear as you're speaking. in some situations you have a video, audio, and then we have this transcript coming into court on its own, magically appearing, can become a improper focus of the trial. Versus here, we have a live expert testifying, and the transcript is just an aid to follow along with the testimony of the person. And I guess that was my question, does the case law distinguishing between those two situations? Because it could be, and I don't know, kind of assuming that the situation that you're referring to, the case law dealing with that, is the former. Rather, they're just witnesses testifying, like a detective, the interviews in Spanish, and here comes this transcript that the court has somehow blessed without doing the more, which what we're doing in this case, to have the actual people come in and say, I'm the translator, this is what's being said, they're subject to cross-examination.
I would like to add one wrinkle. We're focusing on the word transcript, and that's correct. That's what the Martinez case has a whole section devoted to. But the principle of the ruling, underlying the ruling, is that the jury's job is not to be examining and focusing on a transcript, or I would say a translation. Their job is to focus on the recording, the statement itself. A translation or a transcript is just a way to help them understand it, and in fact their job is to determine whether the translation or the transcript is accurate. With the procedure that we're going to be adopting here, I'm not sure if they're going to be seeing any of the video or the recordings, just brief snippets of it. It will be in evidence, but its existence and its importance is minimized. They're going to have a play action with two people playing out the transcript here, the translation here. Don't focus on the word transcript. Focus on the word translation. The translation and not the recording. The recording is the evidence. That's what they're supposed to be considering and weighing and determining whether the translation is accurate. The recording we are pushing to the side, and we are bringing to the fore the translation/transcript of this most important part, and the Martinez court stresses this too. We have to be especially careful if what we're dealing with is something that purports to be the incriminating statements of the defendant. I don't see how this can be determined as not being the focus, an improper focus, the translation/transcript, as opposed to the recording itself. Thank you, Judge.
Judge, if
Yeah.
I could respond.
Yeah.
Martinez, I think the source of confusion here is the Martinez case. And to be clear, defense counsel is citing 761 Southern 2nd 1074, a Supreme Court case from 2000. That case dealt with transcripts and a translation that was where the accuracy was in dispute. That's not the case here. According to what they said yesterday, the accuracy is not in dispute, and that's of paramount importance, because what you're going to have to read before we do our testimony is jury instruction 2.10. So if they're not disputing
In that case, though, that Martinez, were there expert witnesses testifying as far as the interpretation of the item in evidence? Because I can tell you on the other side of the issue, there's a case from the 3rd DCA from 1985. I don't know the name of it. It's 469 Southern 2nd 924, where no interpreter is provided. The jurors in Miami, half of them spoke English, half of them spoke Spanish. Reversible error not to have an expert come in and just leave that to the jury. So that doesn't seem correct to me to do either. But I'm really just focused on the issue of, in Martinez, is that this issue where we have an FBI, I haven't heard the credentials yet, but I did hear FBI interpreter coming in and saying, I listened to this is what's being said, and the only issue for me is it somehow improper emphasis on their testimony to use a demonstrative aid of allowing the jury to follow along in writing. Quite frankly, I'm inclined to have a hard time thinking of why it would be. Although, on the other hand, I'm not sure that's really necessary either, because if you're going to have live people say that, and the transcript is not, it's just going to be handed to them and then handed back, but I'm not sure the utility of that outweighs some legal concern, if there is a legal concern, but that's why I asked the question of, in Martinez, was there a testifying witness like we have here, or was it just the scenario that I've seen where the defense objected, we object to that, transcript, and the judge probably said, no, I'm finding that it's accurate, which I've told you I'm loath to do, because then I'm blessing, the actual evidence as being authentic. I'm giving my stamp of approval to do that, which I've said repeatedly, I think is problematic, and may be buried within the Martinez case as far as
It
what's
is, Judge,
problem.
and that's an excellent question. So, and that leads to my other objection regarding the
It is meaning
transcript.
that's what the judge was doing.
Yes, sir, and they
Right.
discuss it at length.
Which
So
I'm
if-
not doing here.
Right,
This person could be, this translator could be not being accurate,
Right,
that's
if-
subject to cross-examination. I'm not doing that.
Right, and I want to be very clear. We did object to the authentication of this translation and to the specifying of which speaker was which and who was saying what and what they were saying. We objected to all of that. We did not concede any of that. And in fact, we had an almost half an hour long argument about Martinez and authentication yesterday. We never agreed to any of that. What we agreed to, just so it's very clear for the record, is the provenance of the evidence. So the chain of custody, as it were, of the evidence. That Donna Carmichael, and I even discussed this and said this is how I would do it, and in fact that's how the state ended up doing it. Donna Carmichael gets the SD card from Waste Pro. Donna Carmichael then sends it off to FBI. They stitch it together. They then send it to a translator. The translator translates it and transcribes it. We don't disagree that that chain of custody happened, but we do disagree that it's not properly authenticated. And Martinez says...
Although on that point, Mr. Richardson said, it's already been admitted, but it's going to be tied up by Mr., what was it,
Adolfo
Cavallari?
Cavelli,
Cavelli, Mr. Calabi.
and also Detective Newman.
And the detective as well.
Yeah.
See, I'm
Understood,
familiar
Judge,
with
but
his voice, that's the person.
I just want to be clear, we did not concede to any of that. And so specifically to your question, Judge, Martinez says on page 11, the first main paragraph, and it discusses a case in Harris, which is 619 Southern 2nd, out of the first DCA. And I apologize, they must have discussed it earlier to get the full site. But they discuss Harris at length. And what they say is, as discussed by the first DCA in Harris, if the authenticating witness neither participated in nor overheard the recorded conversation as it was taking place, the authenticating witness would be in no better position than the jury to determine the contents of the tape recording. They further go on to quote Harris and say, it was error for the trial court to allow the transcript to be used by the jury where the transcript was prepared by a person who did not witness the events recited in the transcript, which is the exact case that we have here. The translator, who then, they make a transcript based on the translation, did not participate in the conversation and did not overhear it at the time contemporaneously that it was being made.
Which case, that's the Marshall case?
That's in Martinez.
Martinez.
Yes, sir.
What's the citation there?
For the Martinez?
Yes.
It is 761 Southern 2nd, 1074, and the head note, or the reference would be at 1087. So.
Let me look at the case just to be
Yes, sir.
sure I can distinguish it from what I'm doing here.
Yes,
Hold
sir.
on.
Do you need a copy of it?
No, I've got it right here on the computer. I'm looking at it right now.
And Martinez, in large portion, grapples with the use of a transcript. Our case is further complicated than Martinez because ours has a language difference. But I think it's best to just address it as if it were in English in all fours with Martinez, and then wrestle with the complication of language subsequent to that.
So in response, essentially, if I'm hearing them correctly, they're arguing essentially that you have to have a witness present to translate that conversation, which of course is not the law. What I would cite first to in Martinez at section 1080, or page 1083 and 1084, is Martinez says the fourth DCA has explained the general law that the jury may view an accurate transcript of an admitted tape recording as an aid in understanding, so long as the unadmitted transcript does not go back to the jury or become a focal point. In this case, I still don't think there's any question that these transcripts are accurate. The defense, have had it transcribed, and it's almost identical to what we have prepared. I would also cite to the court Fernandez versus State, 21 Southern 2nd, 1055, which is a 2009 fourth DCA case that says that when the state retains a witness to authenticate translated Spanish recordings, there's no reversible error present in that circumstance.
Let me review the Martinez case here. I do believe, in my reading of Martinez, I do believe it's a very important, the distinction between that scenario and this scenario is here. We have an expert on the stand testifying as to his or her opinion about what is being said. Whereas in Martinez, if I'm reading it correctly, it looks like before the trial, the state put on evidence, the judge gave the transcript a blessing, then they played the otherwise admissible video or audio, and then gave the jury the transcript to follow along to. And that I do see as problematic, because there's no witness on the stand saying this is really what it is, subject to cross-examination. But let me continue to read through the rest of the language here. In my first reading of state's use of transcript, I'm not sure which page this is on in Martinez, the first few paragraphs give me the impression that that's what happened. Detectives, corporal, assistant state attorney listened to the surveillance and verify the accuracy of the transcript, and I don't see any mention of an expert being on the stand testifying as far as this is, I'm an expert and these are the words being spoken, this is what it means in English.
Judge, it might save you some time if you flip to footnote 5. Mm-hmm. Footnote 5 says, quote, "We do not address the situation where an expert witness, professionally skilled in understanding inaudible and indistinguishable tape recordings, testifies that the transcript is an accurate rendition of the tape recording." It then cites to Henry versus State, which directly addresses that situation as well. So I think that's the significant distinction that carries the day.
But again, that goes to, just to follow up, that goes to inaudible or things or that you can't understand. And again, they put that witness on, the FBI agent, to say that he did all the audio tweaking to the recording to make it such that you could understand the words better. And I didn't object to that expert. That's what footnote 5 is talking about. It's not talking about a person who is a translator who says, again, if it were in English, there is no witness who could come up and say this is what the tape says, because it invades the province of the jury. It's up to the jury to decide. Our extra wrinkle is that ours is not in English, it's in Spanish, and our entire jury is not Spanish speaking. Some of them are, but many of them are not. So again, that's why I think Martinez stands for the proposition that it does, which is that, again, it has to be a person who is involved in the conversation, because if not, and putting it in an English context only, it's invading the province of the jury for a person to come in and say, this is what this tape says.
So I'm going to overrule the objection. So long as allow the state to use the transcript to assist the jury in understanding the testimony of the witnesses, just for demonstrative purposes, but to be absolutely sure that there's an overlap between the testimony and the transcript. You follow me? There should be nothing on the transcript viewable that's not testified to by the witness. Because that's an improper focus. On the other hand, and this is totally aside from the objection, on the other hand, my concern is this. As I mentioned yesterday, if you have the witness testify in this form and you go slowly and take as much time as you want, the jurors can take notes, and I anticipate that they will. If we give them the transcript, they may be disinclined to take notes. They may be thinking this transcript is going to go back to the jury room with them, which it's not.
Yeah.
So,
We're gonna ask for the instruction that talks about use of a transcript that tells them that it's not going back before we give them the transcript. And that they're not supposed to rely on this, it's just an aid. And I think it's 2.6.
okay, we could do that. I'm just
Yeah. I hear-
wondering if it's not better if the jurors are listening and taking notes as opposed to following along with the transcript, especially you're doing this piecemeal. You're not going to be, it's not going to be coming at them at 100 miles an hour. They'll be able to do that. They'll be able to take notes.
Yeah.
All right, so
Yeah.
kind of,
We'd still like for it to be in, simply
Okay.
because some people
I
are
think
visual
the only-
learners.
The only other issue was the defense wants the first 2 pages off of the transcript. Let me give a copy to Your Honor so you can see
Sure.
what we're working with. And then, Don, do you want?
And Judge, the reason why, just so I can articulate for the record, I want the first 2 pages off. It says audio verbatim translation. Again, that's improper bolstering and aids a province to the jury. It's
Your Honor, we have no
purports
objection to moving the first 2 pages.
okay.
we'll take the first 2 pages off.
I just need a second to rip.
Is this a copy I can use as well?
Yes, sir. That's
Yes, sir.
Follow along. First 2 pages are gone.
And Judge, one more housekeeping thing once we finish with this.
Hold on one second, though. I have a further thought. I want to clarify something I said before, an abundance of caution. I'm going to let this happen, but I do not think that the witness should be able to testify to this speaker is that person, because that does invade the province of the jury. Your other witnesses can do that, but as far as this is concerned, the interpreter would just say, there are 2 people speaking, these are the words being spoken. You follow me?
Well, I guess the issue would be how is the jury gonna know who's who?
Well, that's your problem. That's not my problem. That's your problem. You're saying you're gonna call the other witnesses after, so it kind of creates that problem to do that. But it is a problem because they weren't, they can't, that's like saying their opinion about that issue, and that issue is for the jury. Yeah.
Well, I think that the way that can be clarified is for the translator to testify. The person whose voice is most audible said this.
Exactly.
The person whose
Without
voice
them
is
saying
less
this is the
audible
defendant.
this. Yeah.
Because that was part of the objection.
Can we have
Right.
a moment to go talk to the witnesses too, to let them know?
Sure,
Yeah.
sure,
And then, when the court has time, I have one more brief issue.
sure.
You asked.
And do I understand correctly, just for my purposes, I'm under the impression, you don't have the other witness, that witness is testifying in Broward, right?
That's exactly what I was about to say.
Okay,
Yeah.
so then, and
We're gonna have to do the same thing tomorrow.
that was gonna be my question. We're doing this part today, which gives us even more time to be meticulous about it, which we're gonna need to do anyway. And it is that important, as we've said many times. It's a key piece of the case.
Yeah, and I did make contact with Rose Rosario. I wasn't able to make contact with the prosecutor. She's in the middle of a homicide trial.
So today is, which item is it? Was it 169, 170? Is that what the numbers were? I can't remember.
I think it's 170.
Today is 170, the other dates. These are
Correct,
the other
multi-day.
dates.
Yeah, multi-day, yes, sir.
Through Norma Campos is your witness today?
Yes, sir.
Okay.
Yes, it's 170.
Okay.
Judge, one more objection to the transcript. regarding the redactions, the way that the state redacted it, they put it in like black bars instead of just whiting it out, or putting like a white box over it so that it doesn't look like it's significantly redacted. There are portions of it, may I borrow one of those real quick? Okay, I don't have your redacted one printed out though. No, I don't. Oh, I gave it back to you. Sorry, that's my copy? Okay, sorry, I gave it back to you. I thought that was your copy. There is one portion of it where a large paragraph is blocked out. It is on page, I'm gonna use the discovery number.
2521.
That's correct, Judge.
Just happened to come upon that.
That's exactly correct. So there is a large portion of that paragraph that's blacked out. I don't want the jury to have some impermissible inference that it's something negative, because also, okay, the secondary objection I have is to this transcript now, based on Your Honor's ruling about the witnesses testifying who the speaker is, that just this speaker is closer to the microphone. The way that the transcript is made, it has my client's initials and Eric's initials.
Right.
So based on Your Honor's previous ruling, there's another objection to the transcript.
I
That
mean,
it does,
with regard to the parts that are blacked out, if you were to listen to the audio pursuant to my other ruling, what we would have done is, like on that page, it would say, "Oh yes, relax, relax, dude." Then we would stop it and go to, you follow what I'm saying?
I do, Judge. It's just,
Yeah.
in the stopping, it doesn't show them, again, how long of a portion we cut out. And so
Right.
it's different when you visualize it as
Okay.
a black,
Yeah.
paragraph blacked out, instead of just, it would have been probably more prudent
Yeah.
to do it with a white bars so that you wouldn't see the amount of language that we redacted. They're just gonna say
No.
to themselves,
What's
oh,
the-
what's in there, and why
Yeah.
aren't they showing it to
Well,
me?
maybe the bigger problem too is pursuant to my ruling there too, you have EA and JS, which is Eric Alvarado and Jose Soto-Escalera throughout, which does conflict with the ruling previously at this point in time. What's the state's position there?
I'm not sure. Give me a minute.
Sure.
I mean, first, it's not uncommon to use these transcripts. They've had these transcripts for months, and we only got the redaction request last week. We provided a redacted copy yesterday, and this information and evidence will come out after the translator has testified.
This is the longer one than the other one, right?
It is. The next one is 15 pages.
So
And the,
pursuant to my previous ruling, Ms. Mitten, maintaining your previous objections, but realizing that I'm allowing the witness to testify, to translate, your objection is to using the transcript as a demonstrative aid because it conflicts with my procedure as far as they're not allowed to say that's Eric Alvarado or Jose Soto-Escalera, and the existence of the blacked out portions is prejudicial in that it highlights something is being said that is not being translated.
That's correct, Judge. Both of those are completely accurate.
Given the significance of this piece of evidence at the trial at this time, I am inclined to grant that request, not use the transcript with the jury. The witnesses can use the transcript to assist them. They probably need to do that. But then the jury would be able to take notes and go at your own pace to do that. But I think that balancing that out, it is problematic, particularly because otherwise we would have to, you'd have to amend each and every one of them to black out or to white out the JS, ES entries. The first page does start off saying, identifying who they are as well too. So that's where I am with that.
All right.
Okay?
And finally, as I was saying a few minutes ago, Rose Rosario is tied up in that homicide trial. It doesn't look like she's going to be able to make it up here in time today.
That's fine.
If
We
that's
will
okay.
just,
Yeah.
there again, it gives us more time to be meticulous about this. This is a key piece of evidence in the case. I say that just because that was the highlight of the state's opening statement, and it's just obviously it's a critical piece of evidence, so can do that. I don't think the jury's going to seem to be frustrated at the pace of the evidence going that way, and frankly, the use of the transcript in that regard, I'm really not, in my balancing it out, I'm not sure it's that helpful to them. Anyway, it's a balancing process, so. Given that, are we going right into that testimony with the witness?
One witness prior to that.
Okay. All right, are y'all ready for the jury otherwise?
If we could just have a few minutes just to explain the lay of the land.
Sure, absolutely, yes.
Yeah.
Go ahead and do that, we'll take a break.
Okay, thank you.
You're welcome. I'll actually, let's make it a bathroom break, since I've had a lot of coffee this morning.